Dear all, today we have among us Commander Madhvendra Singh, who is a chartered engineer and a member of the prestigious IEEE. He is an international arbitrator and a fellow of the Chartered Institute of Arbitrators. He is also a member and arbitrator with London Maritime Arbitrators Association, London, and many other arbitral institutions. He completed his master's from IIT Delhi and is also a certified individual in artificial intelligence and maritime laws and machine learning and is a faculty of blockchain and smart contracts. He is an international faculty on maritime arbitration and has written articles and chapters on the subject. He also specializes in maritime arbitration, construction, as well as defense contracts. We welcome you, sir.
Hi, thank you so much. Thank you, Anamika. And I think more or less we have really covered whatever I've done so far. Thank you for that introduction. Thank you.
Yes, sir. So if you allow, we would start with the interview.
Yes, sure. I would rather call it an introduction. I mean, I'm sure people are not interested in interviews anymore. We have so many of them. But rather, if we can learn from each other, that is the best thing. Thank you.
Sure, sir. So, sir, my first question to you is that you have been an officer in the Navy as a chartered engineer, and now you're also a maritime arbitrator. So, I think our viewers would be interested in knowing how your journey has been from being an officer to a maritime arbitrator, as well as member of the FCIR, and also a faculty of maritime arbitration.
Okay. Thank you, Anamika. I think that you're basically asking me about my journey of being in the Navy and then coming to become an FCIR and an arbitrator. So more or less, since when you gave my introduction, probably you have actually covered my journey. But yeah, so more or less from the very early childhood, I've been a very unapologetic optimist, and thing which always excited me was dispute resolution. It was whether between friends or between family, with siblings fighting, you would always be the one who was trying to resolve. So that was something which really interested me. So when I was in the Navy also, there's one very important aspect which I learned was mainly to do with the importance of interpersonal relationships. And what I learned was it's not that you earn your relationships by just being friends or giving people awards and certificates. You really have to be in the trenches with your troops to really empathize with them, to be with them, to feel with them. So that is something which is relevant and important for all of us, interpersonal relationships. So I benefited from it, and not just being friends with the officers in the Navy, but also friends with the outside world. And that's when I got introduced to the ADR, the alternate dispute resolution. So when I was in the naval dockyard, I came across few disputes. At that time, I really didn't know what arbitration is. And that was also the time when Mumbai Center for International Arbitration was coming up. So again, through friend circles, getting to know about what's happening in the world. So that is something which really attracted me from the very first day. And then I went on to do the training with CIR, the Chartered Institute of Arbitrators. I really liked it. And, sometimes in life, it is very important to be able to learn to unlearn. And when it came to learning arbitration, I had nothing to unlearn, actually. So because I'm not a lawyer, because I don't have a particular style of advocacy, so it was easy for me to learn. I was interested in dispute resolution, so I could pick up the nuances of arbitration. And it's really wonderful. I mean, the whole the procedural aspects of an arbitration, the dispute resolution, is really beautiful. And I'm glad that our country has been able to adopt it. More and more commercial parties are adopting it. And I think the future is also very bright as far as the alternate dispute resolution is concerned, especially with the times that we are going through right now. I think that is something which people would like to do. So, see, I have been always something which really excites me is intellectual stimulation is very important. So I've always been learning new things. I've started social service at a very early age. Then I even went into robotics, and then the technologies of the artificial intelligence, and is now the blockchain, which is really disruptive in nature. And the best thing is that you don't feel the disruption. I think the technology which is the best in disruptive is the one which is not felt. But it is inevitable for the future, and I think it's only because of that, the quest for learning, the quest to be good with people, always have a good interpersonal relationships, is what has led to me be an FCIR and become an international arbitrator also.
Thank you for your insight, sir. If you like, we may proceed to the next question, sir.
Yeah, sure, please.
So, sir, the recent COVID, as we have all seen, that the recent COVID pandemic has taken a toll globally, and we have seen various virtual platforms coming into being, and people are sorting to globally the online platforms for learning. As regards to an arbitration, the ODR platforms and the disruptive technologies have also gained life. So, our audience would like to know that what is your opinion regarding the efficacy of these platforms, and whether these platforms are temporary in nature, or whether they would stay after all these things get resolved.
Yeah, Amit, thank you so much for a wonderful question, actually. Very relevant and very topical for the times. See, being a chartered engineer, coming from a technical background, I understand the importance of these technology platforms. And to say that it is the COVID that made people do it, I would not really agree in totality, because I don't know if you have chanced upon an article which I had written about the blockchain and artificial intelligence in the process of arbitration, which I wrote before this COVID thing had happened. And because if you realize, if in fact from 2010 itself, under the aegis of UNDP, the Development Program of the United Nations, India, Mr. Ashwini Kumar was the Minister of Law at that time. They had pumped in like thousands of crores of money in creating of these e-courts. But unfortunately, today we see that, more than India is number 2 in the world as far as the number of internet users are concerned. But if you see the number of people who have access to justice is, nothing comparable. It's few and far. So why is there a gap? Despite people being connected on internet, they still do not have access to justice. The reason is we have not been able to create the platforms which are user-friendly. We have gone in creating platforms, the galaxy of such platforms. But the most important factor with these platforms is there's something called as ICT, which is like information and communication technology adaptation. So if a technology has to be called ICT, it has to be absolutely, user-friendly. It has to be trustworthy, and it takes care of all other things. So I don't think any of these ODR platforms that have emerged are truly ICT as of now. We are working towards it. The second point I would like to make here, Amit, is I encourage the use of word online rather than virtual, because even when the virtual hearing started, because courts started to move on online for their hearings, there is a certain people of a certain age group and taste, would not be very convenient with using ODR. That's because there are so many complexities involved with it. There are, breakout rooms. You don't know how to go to a breakout room, how to make your own groups to communicate without other people getting to know. How was the documents to be exchanged, how the discovery has to be done, how the annotations have to be done, how the questions have to be framed, the transcription things that goes on with the cross-examination, and a lot of other things. And also the kind of advocacy that people have had in the court systems, which is something which is really affecting our arbitration also. So with the ODR also, another thing is that, yes, the question you asked me is whether it's temporary or whether it's going to continue. It is going to continue. It is inevitable that we move on, not only because it is convenient, but it is cost effective. It is less time consuming, which is in the favor of the parties, because all the good things about ODR falls in favor of the parties. So I think there is no reason that people should not move on and be connected with ODR platforms. The only thing is the issues of trust, the issues of the classification, the security classification of the data, the GDPR compliances, the data subject rights, like people, they have their rights to be forgotten. They have rights to deny that access to their data. Wherever there is personal data being used, the confidentiality of it. Amit, I don't know if you must have been noticing that the two biggest news going around right now in the circles of law is, I know one, you have seen what's happening with the adjudication of various disputes. The second one has been the emergence of ODR. So now a word of caution is that what many parties are doing, like mostly the financial and banking institutions, for small category loans, for repayment of these loans, they are funding and investing in creating these ODRs. And then there are unilateral appointments which is happening. And there are templated awards. There is an AI-based templated award which is being given out with the young lawyers who are just graduating from their colleges. And because it's templated, it's easy, and they just go through a small capsule of like 3 hours training to be an arbitrator. And then they're giving these awards in the favor of the parties who have created them mostly. Although it will not be correct for me to say that there's a kind of inclination for these institutions to make awards in favor of a certain party, but there's a word of caution that I'm trying to give is that they must keep that particular aspect in mind when they're doing it. So that is very important, that they maintain the confidentiality of data, the GDPR regulations, the ease of use, the user interface has to be good. It has to be a true ICT in its technological sense. It has to be free of bias. It has to be balanced. And then it should not be having any kind of inclinations to any of the parties. As far as we are able to meet these requirements, I think ODR is an amazing tool for all age groups. And with the times that we are living in, I think this is something which is going to stay with us.
Thank you so much, sir. In addition to the same question that Amit put, considering we are talking about ODR as well as virtual platforms, what kind of use and discussion do you think would be with regard to disruptive technologies, especially in the maritime industry? And how do you think arbitration or maritime arbitration can go forth from there?
Yes, again, Anamika, thank you for a good question. So, disruptive technology, yes, it's a very intriguing word, disruptive, because people don't like that uses it as a negative connotation. But disruptive in the sense, a technology which is not only makes improvements in the way you work, but it completely disrupts the way you work. I think the technology is like, in fact, let me tell you one thing about Amit and Anamika, that, there has been, I think, as far as the democracy is concerned, I don't think there is truly a democracy in the world except internet. Internet is the most democratic thing that I know of, because it doesn't have any kind of inclination to people. It is absolutely similar to use by everyone. So that is the importance of use of internet, which people must understand. And for a very long time, people have been working to get new technologies to make their lives easy, automations. Then they went into the industry standards 4.0 now for the business standards also. And but it is the advent of blockchain which really changed everything. Because even for the maritime business sector, if I tell you, like there's something called as electronic bills of lading. And even the Hobbies rules and the Rotterdam rules, United Nations Convention on Use of Electronic Documentation of Communication, which permits usage of electronic ways of communication and electronic bills of lading. But it's been 20 years or at least 15 years since the invent of electronic bills of lading, but that did not take off because they were relying on a central registry form of exchange of bills of lading. So between a carrier, a shipper, and a consignee, the bill of lading would exchange hands and get returned to the shipper in the end. But unfortunately, the reliability was so low, and that the key encryptions could be broken, and then they could actually be fraud. But with the blockchain, the kind of immutability it brings with it, the kind of data reliability, and then everybody on that platform is privy to the same truth. There is no way that somebody can fraud in that. So it is only with the advent of blockchain-based electronic bills of lading that electronic bills of lading have become acceptable. And also, as far as the disruption of technology is concerned, let me tell you that we are not very far from the times when there will not be any governments. It's a big statement I'm making. But like Mahatma Gandhi said, I remember reading from his biography, is that the best governance is the no governance. As of today, I think every aspect of our lives is being governed at a very extremely high levels. But with the invent of blockchains and the cryptocurrencies, and even the blockchain actually enables the use of autonomous execution of smart contracts, which has made exchange of financial exchanges, the monetary exchange, very reliable and trustworthy. So imagine of a scenario where people are doing business among themselves without a third party, which is the government, intervention or control, and including the financial transactions, and without losing the much necessary control and the trust between the parties, which is the role of the government actually. So that is how the blockchain disruptive technology is going to rule our lives. It's going to change everything. And also with the maritime arbitration, it is basically also very important to understand the way the business work, the maritime business works, the nuances of the business itself. So if this is the kind of technology disruptions that are going to happen in the business, of course the arbitration and the dispute resolution will also have to keep a pace with that.
Thank you for your insights, sir.
Yeah.
We would now like to know, sir, as we have been discussing about maritime arbitration, and we have heard about your journey to being an arbitrator. What, according to you, is the scope of maritime arbitration in future? And also, what would be your advice to young budding lawyers who want to pursue their career in maritime arbitration?
Yes. So, Amit, thank you for your question. So, again, so I have been interested in maritime arbitration, and also I've been taking training sessions. Internationally also I've done, and here also with the Gujarat Maritime University, I recently concluded a training session. So to begin with, to understand what maritime arbitration is, mostly people would confuse it with saying it's maritime law, training on maritime law or on shipping law. But maritime arbitration has three sides of a triangle learning actually. One is the procedural aspects of arbitration itself, where you would have to learn the ancestral model law to begin with, the New York Convention. You have to understand what are the soft laws of IBA guidelines. And then you have to understand the arbitration and the conciliation act of a particular jurisdiction. And then the second side of the triangle would be the various conventions and laws that are applicable. All these conventions, there's something called as Lex Maritima, that is called in the maritime world, which is basically a group of all these conventions that have come about. And the power that is drawn to these conventions, why would countries agree, and parties, engaging with each other in maritime contracts would allow a particular convention to apply to their trade, is that basically the power is drawn from the Article 38 of the statute of the International Court of Justice, which allows all the kind of conventions and treaties and exchange and programs to be valid and enforceable. And the third side, and very important to the critical side to the maritime arbitration, is the practice of the maritime business itself. And that is why if you see very uniquely in the maritime arbitration, there is a practice parties prefer only the experts from the maritime industry to be sitting as arbitrators. So whether it is London Maritime Arbitrators Association, or whether it is SMA from New York, or even the China Maritime Arbitration Center, or even the Singapore, which is recently budding, even the EMAC and all, they all have their rules which make it convenient for the parties to choose an arbitrator which has that expertise. I think this is one of the most unique features of maritime arbitration, where let's say 95% plus arbitrators are appointed are the maritime experts. A few other unique things about the maritime arbitration is also with the number of arbitrators. if you see, maritime arbitration sees even a majority of ad hoc arbitrations, but they use institutional rules. So LMAA does not administer arbitrations. They only have the rules, and the arbitrations are actually ad hoc arbitrations. So there is a provision that both the parties can choose their arbitrators without any presiding arbitrator. And the two of the arbitrators, the panel can adjudicate on the matters of procedure where there are no substantive issues. And the documents only arbitrations is also one of the features which is very common in the maritime arbitration. So two arbitrators are also allowed, and then they could probably have a presiding arbitrator or an umpire to basically adjudicate and decide on the matters of substantive matters or even the procedural matters of their disputes. So that is how, I mean, even in the practice of maritime arbitration, it is important that we have an ecosystem which is where there is a exchange of rights and obligations. Therefore, there are disputes, and when there are disputes, the practice is good. So, as an arbitrator, you can still sit as an arbitrator internationally, but as a counsel, as a practicing counsel, since we do not have reciprocity with many jurisdictions where their lawyers can't practice in India, so Indian lawyers can't practice in their jurisdictions. For a counsel to practice maritime arbitration in India, it's important that we build an ecosystem which provides for an environment where there are disputes, where even in fact you know that the Admiralty Act, the Jurisdiction and the Maritime Claims Issues Act, has been recently revised in 2017. And the jurisdictions have now been increased to 8 high courts, 8 coastal high courts. And therefore, there is a big amount of impetus in the country also to create an ecosystem like that. So that is why I think it is important that there's a system which allows the practicing counsels to deal with the matters of maritime action. So that is how the maritime arbitration will also become. Yeah.
So again, following up to that question, since considering the new changes that have been taking place, or adaptation to the new normal, as we can call it, how do you foresee the growth of maritime arbitration as a profession in India, considering the technology disruptions which are taking place both globally and nationally? And also following up to that as well, how do you think maritime arbitrators, especially in India, should work or kind of pursue maritime arbitration as a profession in their particular field? How they should grow or develop in that particular field?
Yes, thank you, Anamika. And, what I understand you're trying to ask me is that how should the budding lawyers who intend to sit as arbitrators to adjudicate maritime dispute must keep pace with the changes that is happening in the business of maritime trade. So yes, in fact, I've find that the law always catches up with the technology. It's not, it's not otherwise. It's not the technology that is playing a catching up game with the law. But whereas the shipping industry is concerned, it is the technology that is catching up with the law, with the industry. Because shipping industry, though it is very conventional in nature, but has always been very, innovative and acceptable to the new technological changes. So that is why it is the technology which is always playing up the catching up game. Like I mentioned to you, the invent of the electronic bills of lading. Because see, even in times of COVID, when the ships reached their ports of delivery, but the bills of lading wouldn't arrive. So the late time charges, I mean, the demurrage charges would just keep piling up. What do you do in kind of certificates of liabilities from the shipper and all those things? So those kind of problems would be there. So now we must understand that how the new conventions are basically emerging. One should always keep pace with that. If you see, for example, even the Hamburg rules or the COGSA, that is called as, that's the Convention on the Trade by Sea, the Sale of Goods by Sea Act, which is the principal act, but which has taken various forms now. We see they got evolved in the forms of Hague rules, the Hague-Visby rules, and then the Hamburg rules, even the Rotterdam rules as of now, which basically catered for certain shortcomings which are there in the act. to basically make good of it. So that is the evolution process that they always go through. And then the technology itself, yes, now what are we talking about is the complete automation in the shipping industry. The faster processes, faster ships, faster loading and unloading of cargo at ports, and satellite communications. In fact, you could undertake maintenance sitting at the harbor, and all ships' navigation and everything could be updated in real time to avoid damages. You know the incidents that happened in Mauritius. You know the recent incident of Colombo, where the fire on board a merchant ship, which got saved in time. So the connectivity issues is one thing which is going to change. We are talking about 5G for ports connectivities and shipping connectivities. There are the complete digitization of the shipping industry is underway. If you know, there's a collaboration of six of the biggest shipping firms, which came up to create the platform, the digital platforms for the connectivity. One of them is called as a trade lens. And if you have been following the maritime news, you would have learned that the Kochi Port Limited, the Kochi Port was the first one which went online, digitized and connected to the trade lens. And the next one was the Adani Port. They have used this application program interfaces, various APIs that we call them, to connect with the trade lens. So what is happening is all the exchange of documentations and the contracts that are happening online, happening digitally online. So there's a singular platform which has connected the shipping world now. Every kind of standard form contracts, which are very common to the maritime industry, will now get standardized. The terms will get standardized. And something which is very unique to maritime businesses, like most of the contracts, the bill of lading in the maritime world is called as the Holy Grail, because you always vouch for it, but you have not been able to arrive there. And then you have the charter party agreements, and the bill of lading contracts are very common, and majority of them are like bill of lading contracts. But now the incorporation of the clauses it happens by reference. So this is one issue, incorporation of clauses by reference from a third-party contract or from a main contract, or the matrix contract they call it. So that has been addressed over the years, and even till now there is no clarity on this. So recently, in a case, there's a case law, WALCAF, where they have courts have come out on the liabilities of the parties and burden of proof and all those issues. So these are the things which one must keep pace with. And the maritime arbitral institutions like LMAA is one of the best to keep an eye on. And there, one thing which I have been voicing in various platforms and being a member and arbitrator with them, and in the various forums also, is that commonality in the understanding of the various laws. Because now the complete, as the shipping industry gets united on a digital single platform, it is important to understand these laws with a common understanding. That will only happen if we have all these awards that are coming out of these arbitral institutions get published. So all of us read a similar case law to understand the applicability of a particular clause in the law. Then we will have a common understanding across the world, because maritime is very international. Maritime has a very international feature to it, unlike other businesses. So that is what is very unique to it, and that is how people, all the budding people, who want to be maritime arbitrators, they must always keep an eye for this, and they should always keep themselves updated with these kind of things. So I think that would be my advice, in short. Yeah.
Thank you for your valuable insights, sir. Lastly, this question I would like to ask you. So there's a famous saying we go by, that all work and no play makes Jack a dull boy. As now the world is learning to this new online system, so it becomes very necessary to maintain a work-life balance and between the work and finding time for the things you love. For the things you love, our audience would like to know, sir, that how do you maintain the same, and what are your favorite hobbies, and how do you go about these things, sir?
Yeah, Amit, thank you for that lovely question. I mean, that is very important. I don't know why people take hobby as a, I mean, it's a cliche, but people take it in a negative sense. I don't know. People are so busy with their work, they think you ask anybody, so what do you do? So he will tell you what work he's doing. And I believe they find that kind of a satisfaction at work. And fortunately, by being in the military, I've been exposed to various facilities for sports and extracurricular activities. And over a period of time, what I have been able to do is, build hobbies that are sustainable for life, which is also important. So, like, I really like to do underwater diving. There is one thing that you're underwater, you really have no margins for error. And then the weightlessness that you feel, and that kind, you're free from all kind of stresses. You're just focusing on what you're doing underwater, on your breath. It's a wonderful hobby, and I think it is sustainable for life. Also, I love playing golf. Again, a very technical game where you're playing against yourself. It's a saying that in the golf world you don't really have to play against anyone, and it's the epitome of patience and persistence that you have to show. And also, I like riding. I mean, horse riding is one of my favorite hobbies. So I really do it at times, but it is. I know it is not sustainable for life, but yeah, hobby riding is sustainable for life. So I would want to choose to use a word here. I mean, without any doubt, that hobby is critical in life. Okay, it's not a matter of choice. Everyone must have an hobby, because also from the other side, that if people don't have a hobby, that will be overburdening for your colleagues and workers, and also for your family. I mean, because if you have hobbies, you will know have your time, how to utilize your times. And also, and I'm sure you also know from the schools also, that people who are good in academics as well as in sports always did well in life. So it is important. It gives you an overall personality. And also, there is one thing which is important, like when we were beginning, I told you about interpersonal relationships. That is also one good hobby that people can have, to keep building upon the new techniques, the new ways to deal with people. I mean, in today's world, it is very important. Although we are meeting online now, but still, it is even more important that how you innovate, and the whole kind of that art of communication, the art of negotiation, the art of talking to people. That is also very important to learn. And also, if you ask me, like two characteristics which embolden, like in the Sanskrit, there's saying which say that Jagat Vijayantu Purushartham. We understand what is Purushartham. Like, it is, you have to do your work. You have to do what you are supposed to do, actually. So that is, with that essence, the two qualities or two very important attributes of life which I could tell you was, one was fortitude, and other one is empathy. This world is really truly lacking empathy, and it is very important that we empathize with people, try to understand people, and connect with them on a more personal level. So I think, in short, that would be my advice for the young budding lawyers and the people, and the things they can do. Pick up hobbies. Talk to people, build your interpersonal relationships, keep up with the technology, keep up with the changes that is happening in the maritime world, keep up with the laws and conventions, read and write. I love to read and write a lot. So I finish my work, like come back home like 7, 8 o'clock, and still I spend a lot of time, like at least 2 hours every day to write and read. And I think it is very important to read, but also to write, because writing meaningfully is an art. Writing is not an art, okay? People can write, but writing meaningfully, which you must understand is important, because people generally take it as write. So they will write whatever comes to their minds. So recently, my article was published verbatim by a platform without asking my permission. So you can understand the kind of things that are happening. The young guys are very quick to, just write something because there's a pressure. They will just pick up some literature from here and there and then just publish it. So you just apply. One has to apply themselves. They have to do some research online, and then come up with something meaningful that somebody who's reading it, it contributes to his knowledge. It should not be a gibberish. Yeah, somebody has written, and okay, just you have to fill the papers, you have to fill your magazines, you have to fill your blogs and everything, and just keep pace with it. So write meaningfully, and for that you'll have to read a lot. I think these, in a sense, are the things which people should do to keep pace with the changing times. Yeah.
Thank you, sir. I think this has been, apart from gaining knowledge, this has been a really insightful advice to all the budding lawyers out there in all the fields, whether it be civil, criminal, maritime arbitration. So that concludes our round of questions, and or as they're called, interactive session with Center for Maritime Law, National Law University of Odisha. We are really thankful to Captain Singh for taking time out of his busy schedule, and it was indeed a pleasure to learn from you, sir, and getting an insights from on all the subjects relating to maritime law. We hope that we get an opportunity to learn from you in the near future as well. Lastly, before signing off, I would just like you to give an advice as to how the center should function and as how the center should progress. So
Yes, see, I'm truly very proud of my alma mater, which is IIT Delhi. And if you have seen the news lately, whether it is COVID, whether it is international exchange programs, I think they're doing a wonderful job. And for any university, it is very important that how you become truly global and international in the true sense. That will happen when you collaborate with the international universities. You have exchange programs, student exchange programs, and then you should continue to work on your programs which you are teaching and training that you give in part. And also, like both of you, like Anamika and Amit, you have come out, you have really arranged this kind of interview or interaction with me, so you can continue to do these things with all different people, from the different sectors of business, from sectors of law, and everybody. It gives a lot of good insight into what is the new things, what people should do, and also very importantly what people should not do. And as an institution, we should always look for what is I call it the foresight, cater for the changes that you're going to see 10 years from now. So one must always have a long-term perspective plan, a 20-year long-term perspective plan, where you want to be, because unless you know where you want to go, you will not know which path to take. So if you have your objectives and the goal clear, only then you will have a particular path to take. And then you should always have a medium-term goals. And these are the kind of leadership styles which all the management in these institutions must exercise. And from the top level to the lowermost person, I should not use the word lowermost. In that vertical field, everybody who's equally responsible for that institute must be aligned with that thought, with that goal, and should work, comprehensively. They should interact, build their interpersonal relationships, and you must emerge and talk to the world. Don't remain within yourself. Don't protect yourself. The quality, of course, has to be maintained. But as you start to interact with the world, as you open up, you will learn and understand that what are the good practices, and then you'll start to adopt them. And then your students are truly ambassadors of everything that your institute has been doing. So your institute must very importantly take it as an essential job to be a cradle of leadership. You have to. Anyways, anybody who has come to the National Law University of Odisha, will become a lawyer. There's no doubt. But all of those lawyers are going to be different. Is it possible that all of the lawyers which pass out of NLU Odisha becomes the leaders of tomorrow? Yes, that is possible. But that will happen if you have the foresight that this is not an institute that is just teaching law. This is an institute which is creating leaders for tomorrow. But we are teaching them law in the field of law. So that is what should be the objective. And I think when you do that, when you open up, when you connect to the world, you absorb all the good quality people who really are willing to do things for you. You allow them to come and work and associate with you. You don't keep your doors closed. Only when you give out will you also be receiving. So in a sense, I think that is important as an institute. And I think you're doing a wonderful job. And in the last, I I'm actually running short of words and adjectives to use now, because English is, I mean, feelings are very limited by language. But I really want to thank you for reaching out and for having organized this interaction, because it benefits me more than what benefits you, because sometimes it is important to also express what you feel, so that I will be really glad. It will be an honor if even one person could, learn from what I have said today. So it will be a worthwhile exercise. And I look forward to continued interactions and engagements with you and your institute. And wish you both personally all the very best on all your endeavors, and all the people who are in your institute and your families. And do take good care of yourselves. Don't go complacent now. It is critical times. Take precautions. Encourage everybody to be safe. Take precautions, and pick up your hobbies and learn. Thank you so much. Thank you, Amit and Anamika, for making this wonderful. It was really nice interacting with you, and all the best.